But we begin our show tonight with the historic civil rights cases that are going to be argued starting tomorrow in the United States Supreme Court. We now know what the TikTok's going to be like in terms of how this gets argued. It'll start at 10 a.m. Eastern. The oral arguments in the case will last an hour. Now, as always, there are no cameras in the courtroom, no still cameras and no video cameras, and there will be no live audio feed from the courtroom either. But we do know that the court plans to release the audio recording of the arguments not too long after they finish up tomorrow. So by this time tomorrow, right here in Tomorrow Night's show, we probably will have the audio tape of those arguments to play for you. The pro-gay rights side of the case is arguing for striking down California's ban on gay marriage. That will be argued in part by this man, the nation's Solicitor General, Donald Verrilli. The Obama administration has taken the pro-gay rights side of this case, and so it'll be our nation's Solicitor General making part of that side's oral argument. The other part of the pro-gay rights oral argument will be made by this man, the former Solicitor General from the last presidency. Ted Olson, Theodore Olson, is probably the most recognizable conservative legal figure in the country who is not himself a Supreme Court justice. Ted Olson was George W. Bush's Solicitor General. He played the role of Joe Biden to prep Paul Ryan for the vice presidential debate this past election. Ted Olson very famously won the Bush versus Gore Supreme Court case on behalf of the Bush side after the Florida recount. It's Ted Olson and the Democratic lawyer, David Boies, who he beat in that case, who are both on the pro-gay rights side of this case tomorrow. But it will be Ted Olson, the conservative one, who will actually stand up tomorrow in court and make the case alongside the Solicitor General. It's kind of the definition of heavy hitters, right, when it comes to Supreme Court oral arguments. The Solicitor General and the last Solicitor General from the other side of the aisle. Wow. Now, that's the pro-gay rights side. The anti-gay rights side, the other side of the case tomorrow, will also be argued in tomorrow's arguments. The lawyer for the anti-gay side will get equal time, and the lawyer on that side of the case is a man named Chuck Cooper. Chuck Cooper. Chuck Cooper. To the Google, right? On the first page of Google search results for Chuck Cooper, you will not find what you are looking for. The first result is this very nice website I think we've got here. Yes, for the Broadway actor named Chuck Cooper. He's very talented, very famous on Broadway. He is not the Chuck Cooper making the anti-gay rights argument at the Supreme Court tomorrow. The other first-page results for Chuck Cooper will teach you about the first African-American player to be ever drafted by the NBA. An amazing history, an amazing biography. There is a foundation in his name, but he is not the Chuck Cooper making the anti-gay rights argument at the Supreme Court tomorrow. Flip over to the second page of Google search results, because you still are not there yet. You will find Chuck Cooper, the nature photographer from Tennessee. He's also not the Chuck Cooper making the anti-gay rights argument at the Supreme Court tomorrow, nor is the Chuck Cooper who is an insurance agent in McGee, Mississippi, nor is the Chuck Cooper who is a realtor in Walnut Creek, California, nor is the Chuck Cooper who is the wiring and cable manufacturer's sales representative either. In order to get anywhere near anything useful about this Chuck Cooper who's making the anti-gay rights argument at the Supreme Court tomorrow, you must call upon the Wikipedia disambiguation page, whereupon you will finally be able to narrow it down to, oh, yes, finally, okay, that must be him, Chuck Cooper, former Supreme Court clerk, now a lawyer, honestly most known for his bit part in the Iran-Contra scandal. He was the one who testified that Ronald Reagan's CIA director, Ronald Reagan's national security advisor, and a man named Oliver North had all conspired to lie to Congress in the Iran-Contra scandal. He actually testified that Oliver North had lied a bunch of other times as well, and he might lie under oath when he was called the next time. Mr. Cooper at the time was an assistant attorney general in the Reagan Justice Department. And that, honestly, is sort of where he is indexed in our modern American history books. Nothing against Mr. Cooper here. He is a very accomplished lawyer now. He's an accomplished litigator. Arguing before the Supreme Court is no chopped liver. But this imbalance is kind of a microcosm for what's happening on this issue right now in our country. The pro-gay rights side, I mean, for one thing, they have essentially totally captured the Democratic Party. President, vice president, the other most prominent Democrat in the country who is not the president or vice president, by which, of course, I mean Hillary Clinton, they are all on record now, emphatically for full equal marriage rights for same-sex couples. A lot of prominent Democrats had that position already, but all of the action now on the Democratic side is among Democrats who were not yet on board, getting on board. Today, two more centrist to conservative Democratic senators came out in favor of same-sex marriage, Senator Claire McCaskill of Missouri and Mark Warner of Virginia. I mean, there are definitely some relatively prominent Democrats who are still trying to dodge the issue. Hi, we can see you. But honestly, if you talk to anybody who's taking these issues seriously, it is now officially inconceivable that the Democratic Party would, say, nominate a presidential candidate in 2016 who doesn't believe in equal rights for gay people. It is a settled matter in the Democratic Party. So the pro-gay rights side has pretty much captured the Democratic Party. It's just a matter of sweeping up the last few and finding out if anybody's going to try to be the anti-gay maverick on this issue while still staying in politics and still staying in the party. My bet is no. Not even you, Mary Landrieu. Also on the pro-gay rights side, along with almost the entire Democratic Party, is a chunk of the Republican Party. I mean, the Republican officials' brief for the Supreme Court ended up with 131 names on it. Everybody from Paul Wolfowitz, my buddy, to John Huntsman, to Clint Eastwood, to the Romney for President campaign manager, to the secretary of the New Hampshire Young Republicans. More than 130 Republican officials and former officials. But even with that brief, and even if you go beyond just that brief to consider pro-gay rights Republicans who didn't sign on to that, but we still know their position, even with all of that, it is still a stretch to even say that there is a split in the Republican Party on this issue. I mean, of the 232 Republicans in the House, precisely 2 are on record as pro-equal rights for gay people. 2 out of 232, that is less than 1% of elected Republicans in the House. In the Senate, there are 45 Republicans. Precisely 1 of them is on record as pro-equal rights for gay people. And that's brand new for him. That's Rob Portman, who just came out with that position 2 weeks ago after saying that his son is gay. So 1 senator out of 45 and 2 representatives out of more than 200. That's not a split in the party. That's like a sliver of the party. That's maybe even a splinter of the party among elected officials. But as with other social issues in Republican politics right now, Republicans are sort of getting to the point where they don't want to change their policy position on these matters. They just don't want to be known for what their policy position is on this matter. They just want people to stop noticing it. So even though the party platform for last year's election, and the Republican Party chairman, Reince Priebus, and the Speaker of the House, John Boehner, and the supposedly modern new Republicans like Marco Rubio are all on the record now as still rigidly anti-gay rights and not planning on changing, even as pretty much everybody active in high-level Republican politics who is not named Rob Portman continues to stand firm against the threat of gay people having equal citizenship rights, at the same time, they mostly just don't want to talk about it. So you have this sort of incoherent thing going on the Republican side, or at least the anti-gay rights side of this question. We're at a point where the face of crusading anti-gay rights activism in Republican politics is an obscure lawyer from the Iran-Contra scandal named Chuck Cooper, who's not to be confused with the more well-known actor of the same name. I mean, to find somebody to be the face of what is the de facto position of the Republican Party, you got to go to this guy, right? You got to go to drag out old Gary Bauer, like Fox News Channel did yesterday. Got to drag out Gary Bauer to argue that people are not really in favor of marriage equality. The polls are skewed. Gary Bauer's argument on Fox News Sunday was that people, Americans broadly, really do secretly hate gay people, but they're lying to the pollsters about it. The same way they told the pollsters they would vote for Barack Obama, and then on election day they all showed their true unskewed colors and voted for President Romney. Really, Gary Bauer? Really? You're the best they've got? This is the de facto position of the Republican Party, but Republicans don't want to argue for it. So you get Gary Bauer, you get old Tony Perkins there on CBS making a same version of the Gary Bauer argument. The polls are skewed. You get Rick Santorum out there still, now running the issue like a racket in a way that would make Newt Gingrich proud. Rick Santorum is now sending out direct mail appeals saying that if you send him $100, he will urge the Supreme Court to rule against gay marriage. Because presumably Rick Santorum can't do that urging without your $100. He's running it like a racket, but this is what it's come to. It's a mess on the other side of this argument from where David Boies and Ted Olson and the Solicitor General of the United States are, and from which they are going to be arguing tomorrow. It's the eve of the oral arguments. Nobody knows exactly what's going to happen tomorrow or what legal direction the justices are going to take this in. And you can double that for the Defense of Marriage Act cases that are going to be argued the following day. There'll be nearly twice as much time allotted for the arguments the following day as there are tomorrow. We don't yet know how this all is going to move legally. But the politics surrounding this legal matter are increasingly coherent and weighty and predictable on the left. And on the right, they are increasingly incoherent and low rent, and even occasionally pathetic. Does that imbalance in the politics here? Does the fact that the spokesperson on the right on this issue is maybe Gary Bauer, and the spokesperson on the left of this issue is the leading legal lights of both the Republican and Democratic parties, does that imbalance politically affect expectations for how the court is going to hear and rule on this case? And should it? Joining us now is Kenji Yoshino. He's the Chief Justice Earl Warren Professor of Constitutional Law at NYU Law School. He'll be in the courtroom tomorrow to hear the oral arguments in the Prop 8 case. Professor Yoshino, thanks very much for being here tonight.
It's great to be here, Rachel.
First of all, can you sum up for us, what is the basic question the court's going to be deciding in the case tomorrow, and what do you see as the range of ways they could rule?
Great. So there are two claims being made constitutionally. One is a freedom to marry claim, which is, under the Due Process Clause of the 14th Amendment. The other one is an equal protection claim, which says there has to be equal treatment regardless of what entitlement is on the table for same-sex couples as for opposite-sex couples. Right? And so the range of options that we have with those claims are, usually people frame it as 0 to 50, so it's either Manichaean, so it's either no states or all 50 states, but there are actually three options in the middle, and I think that the court is most likely to do one of those three. So there are two ways to get to one state: a just California solution. We can talk about either of those. And then there's an 8-state solution that says there are currently 8 states. It will be 9 when Colorado does civil unions on May 1st. But 8 states that have everything but marriage. And the argument there is if you are giving all the rights and benefits and burdens of marriage to individuals, but you're withholding only the word marriage, that's essentially a branding issue. It's a concern that you'll tarnish the brand if you let gay people into the institution. And that tarnishment claim is really a second-class citizenship claim, and so the court could flip those 8 states or 9 states and double the number of jurisdictions that have same-sex marriage.
And that would mean that the states where same-sex marriage exists already would continue to have that, but it would not force other states that don't have those laws to respect them.
Correct. And so what it would say is that you have all of the states that have everything but marriage statutes being pushed over into marriage, because the argument is that it's irrational to give all the rights and benefits and burdens of marriage, but to withhold only the word marriage.
Okay.
Right? And so then that would basically end civil unions, because I think states would get very leery about going too far down that path, lest they be pushed over the edge. But I think that civil unions have already seen we've seen the dusk of civil unions already. I think gay people want full equality, and they're not willing to sort of settle for the middle of the bus as opposed to the front of the bus.
Is it possible that the ruling on this case tomorrow could hurt gay rights, in the sense that it could roll back existing rights or make it harder to achieve forward progress that's already in motion?
Well, it could, in the sense of saying we could get something like a Bowers versus Hardwick type case, which is to say that's a 1986 claim that said that there was no constitutional right to have privacy against laws that criminalize sodomy, and it took 17 years to get rid of that case. So it could create a negative precedent that said there is no fundamental constitutional right to same-sex marriage, and that could take a long time to get rid of. But even that kind of a decision would not preclude us going from state to state and flipping states one by one under either state constitutional provisions or through the legislatures.
Okay. So I know you're planning on going to oral arguments tomorrow, what do you expect to know after the oral arguments? What are you watching for? What should we be looking for when they release the tape in terms of either tipping their hand about which way they're going to go or what might be important in their ruling?
Right, so one important thing to look for is the off-ramp, which is the big kind of standing issue, which is, are the right people bringing this case? So one of the ways in which the Supreme Court could kick this case without having to reach the merits of the case is to say, this case may be meritorious or not, but the wrong parties appealed this. It should have been either the governor of California or the California Attorney General. Since they declined to appeal, the proponents of Prop 8 are the ones who are in court, and they're the improper party, so we're going to kick it, and it goes all the way back down to the district court, and that would flip California and California only. So listen for that procedural issue. Another issue is how the court wrestles with this issue of political powerlessness that you laid out earlier, right? Because on the one hand, you have 41 states that currently have restrictions on same-sex marriage that do not allow same-sex marriage. On the other hand, you have polls like the ABC Post poll that say 58% of Americans are for same-sex marriage now. So what do we do with this? Because the other side of this, the proponents of Prop 8, are going to argue that gays are so politically powerful, they don't need the special judicial solicitude that is offered by the court under this heightened scrutiny standard that the plaintiffs are seeking. And the way to resolve this, I think, Rachel, is to say, this is a paradox of political power in the Supreme Court, right? That you have to have an enormous amount of political power before the court will deem you to be politically powerless. And so that the truly politically powerless individuals in our society are not going to be on anyone's radar, including the Supreme Court. So unless we had had this enormous gay rights movement over many, many decades, we would never be at the point where the court was even had the question teed up before it as to whether or not gays were politically powerless or not.
Oh, this is fascinating. This is going to be one of those cases, followed by the DOMA cases, which are just as complicated but also as far-reaching the following day when I have absolutely no idea what's going to happen. The fact that Chief Justice John Roberts' lesbian cousin will be sitting in the audience tomorrow, hearing oral arguments as well. It's like the personal mix and all the middle of it. This is going to be an amazing one to watch. Kenji, thank you so much for being here.
It's my pleasure.
Kenji Yoshino is a professor of constitutional law at New York University. He's the professor of constitutional law whose job is named for Chief Justice Earl Warren, which means he's an even bigger deal than you think he is.